Do you qualify for Italian citizenship? Today I'm answering your real questions. And at the end, two important ones about the 1948 rule and minor rights. Stay with me, some of these answers may surprise you. Question number one, Pasquale. My grandmother and grandmother were both born in Italy and lived their whole life there. But my parents came to America and became US citizens when I was a child. Can I still go through my grandparents for citizenship? Hello, Pasquale. The answer is yes. It's possible to apply through grandparents as long as the Italian citizenship was never interrupted by naturalization before the birth of the next person in the line. We need to check that the exact dates of your parents' naturalization and your birth. If they naturalized before your birth and before 1992, we could evaluate a court action. This is because before 1992, there was no possibility for dual citizenship, so the loss was automatically and not voluntary. For example, I've seen cases where parents didn't even know they were losing citizenship at the time. Yet their children were able to restore it through the courts. As I always say, and I know I'm boring, every case is different, so it's always best to get a personalized consultation. Next, we'll talk about what happens if both parents naturalize before you were born. Question number two is by Joe. I'm first generation born in the USA, but my parents naturalized before I was born. I heard about a 2-year residency requirement if we don't qualify for Iure Sanguinis. I'd also be interested in filing a court petition. My younger sister is also interested. So, Joe, if your parents naturalized before you were born, you do not qualify under Iure Sanguinis directly. But a court case may still be possible, especially if there are consultation issues involved. The 2-year residence path applies only if you already have partial eligibility under the current law. It doesn't replace the need for a valid transmission of citizenship. For instance, I've worked on cases where the residence option wasn't viable, but a constitutional challenge in court opened the door. Now let's look at a case involving a maternal line before 1948. The question number 3, by Trinidad. Trinidad from Chile, I suppose. My grandmother, born in 1939, is the great-granddaughter of an Italian citizen from Genoa. You mean Genova, okay. We are evaluating starting the process through the courts because it's a maternal line before 1948. She will start the case and then the rest of the family will continue it. What about viability, requirements, cost, and timelines? This is exactly what we call a 1948 case. It's viable if the documents prove that the Italian line without interruption. You'll need birth, marriage, and naturalization records for each generation. This is not the place to talk about the cost, but the timelines vary, but usually 18, 24, sometimes until 30 months in court. I recently had a family in a similar situation. Once the grandmother's case was approved, all the descendants were able to proceed much faster. Up next, a situation where multiple grandparents have different naturalization. A situation where multiple grandparents have different naturalization histories. Yes, it's the question number 4, Joe. And this is another Joe. So, my father from Bari naturalized in 1957. My mother from Sicily naturalized in 1958. I was born in the US in 1969. Some of my grandparents never naturalized. Sorry, but I don't see very well the screen. With all the recent change in the law, is there any path for me to acquire my citizenship? It depends. It depends on whether your line through the non-naturalized grandparent is unbroken. If one side of the family kept Italian citizenship until the birth of the next in line, you may still have a case. With the new law 74, we must check carefully for any constitutional arguments that could apply. In one recent file, a client through there was no chance, but the line through one grandmother saved the case. Now for our bonus questions, starting with a classic, the 1948 rule. Question number 5, Maria Rossi from Chicago. If my Italian ancestor was a woman who had children before 1948, can he still get citizenship? Yes, but not through the consulate, of course. You must go to the court in Italy and file a 1948 case. The old law discriminated against women, and the Constitutional Court ruled that's unconstitutional. I've personally handled many of these kind of cases, and they remain of the strongest path for those affected. We talked about this so many times, and I keep repeating this because this is very important. And finally, what happens if you lost citizenship as a minor? Here is the question number 6 from John Smith from LA. What if I lost citizenship as a minor because my parents became American? Can I get it back? This is complex. The new law 74 changed the rules, but there are still strong constitutional arguments for restoring rights in these cases. It requires a court petition, and every situation must be reviewed individually, as usual. And I've seen minors regain citizenship years later by challenging the automatic laws in court. So, guys, if you have your own question, write it in the comments. We'll answer in the next week's Q&A. And if you want a personal review of your case, please book a consultation through the link in the description, because it's very important. So don't hesitate. I'll be there for you.